J.D. Edwards.
Meeting, please come to order. Clerk, please read the roll.
Adel. Here. Avedisian. Buell.
Here.
Camilleri. Curry. DeBella.
Here.
Gardeau.
Here.
Hall.
Here.
Healy.
Here.
Hoffman.
Here.
Holloway. Iono. LaChance.
Here.
LeBeau. Lester. Magnan. Maniscalco. Mandyke. Murata. Payne.
Here.
Patel.
Here.
Salemi. Solomonides. Sweezy.
Here.
Taylor.
Here.
Vecino. We have a quorum.
Please stand for the Pledge of Allegiance.
To the flag of the United States of America, to the republic which stands, one nation, under God, indivisible,
with liberty and justice for all.
Approval of the minutes of the meeting of January the 6th, 2020. Is there a motion to adopt? Been moved and seconded. Are there any additions or deletions? If not, all those in favor, please signify by saying aye.
Aye.
Opposed? Abstentions? Okay. Item 5, public comments relative to agenda items. Okay. Report from the district chairman. One item. Chris?
Yep.
Yeah, there's a tour of the facilities up in the
Down on Brainerd Road, the
Brainerd
water
Road.
pollution control
The
plant.
water pollution control plant. Chris, would you give the time?
I was asked by a couple of commissioners about a tour of that facility. Mr. Tyler, who heads the operation down there, is giving a tour on Tuesday, February 18th,
Which is next Tuesday.
from 10 to 2. And it's, I'm sorry, 10 to 12, excuse me, 10 to 12, but if it goes beyond that, that's fine. If you could let us know either through Victoria or myself, if you're interested in attending, just so we can get an idea on numbers, that would be helpful. Tom, do you have anything you want to add to that, or?
That's fine.
Okay.
We
Oh, you got to say about wearing boots and stuff, right? Yeah.
will provide the necessary safety gear, hard hat, safety vest, which is required. If anyone is going to participate, we ask that you wear safety shoes if you have them. If not, some kind of hiking boot or work shoes, something like that, just for part of our safety protocol.
Okay. Thanks, Tom.
Tom, we don't have the boots like they have in the tunnel, huh? Okay.
No walk boots.
Okay. Believe me, if you have the time, you should take the tour. When you look at that facility, from outside of the facility, it's massive. When you get into it, it's 3 times the size of what you see from the outside. It goes deep. It would be a good experience.
Chairman,
Yes.
quick question for you. Are we going to get a chance to take a tour of the tunnel once it's completed or not? I'm just out of curiosity.
Well, I think once it's completed, that probably makes a lot of sense. I had the pleasure and the experience about 2 months ago, was it, Susan? I went down with Kelly and Susan, and we went down, and it is a very scary situation. It's a tunnel, one way in and one way out. We were having some problems with leakage of water, were we not, Susan, at that point in time? And we've resolved that. Some of the grouting that was not properly done was having some leakage, and that's been resolved. But it's a very difficult process in there, and I don't think, personally, I don't think it's ready. There's a preparation period that you have to go through to go down there. They show you how to use breathing machines if you have to have them. It's not something that I think at this time we're ready for that kind of a situation. But as it improves, and it will, then we'll do something in that matter. Item number 7, report from the Chief Executive Officer.
Thank you, Mr. Chairman. First off, I'd like to just mention meetings. As I reported at last meeting, we were planning to meet with the town of Rocky Hill at their council meeting on January, which we did, on January 21st. We gave the similar presentation that we had given to all of our towns. A very positive meeting. The chairman, myself, and staff, and Commissioner Sweezy were present. We also have a meeting scheduled for February 20th with Congressman Larson and the Army Corps of Engineers to discuss the Hartford Dike and the East Hartford Dike in terms of the status. We're also meeting with Connecticut Waterworks Association's Legislative Committee to talk specifically about PFAS and the agenda for the water utilities and how we and what we believe is important to the MDC. The one thing we have to really consider is the MDC is unique. The other largest water utilities in Connecticut are just water utilities. We're the only water utility and wastewater utility. So a lot of the discussions that are occurring right now regarding PFAS is associated with airports, fire protection. There's no discussion about landfills, and the largest contributor to PFAS to the Connecticut River or to the MDC Hartford Treatment Plant, which is the largest in the state, regarding PFAS. So we want legislation to look at not only fire protection and not only airports, but also discharges from landfills into the MDC's sewer system. And what we're looking for is for point source protection. So we're expecting anyone who's discharging PFAS to our system, that it's treated at the source. And again, DEEP's already proven through their pilot program in October of 2018 that they can actually remove the PFAS below levels mandated by EPA, which is 70 parts per trillion. So that's what we're looking for, and we're going to be pushing the utility industry for that. We also have just been requested, as we've been talking about with our stakeholder meetings with our towns, is that the town of Windsor and Representative Jane Garraby has asked, and the mayor asked, that we come in on February 27th to talk about water bills and explain the water bill and some of the charges, a clean water surcharge that we've been talking about over the last number of months. I'm also meeting with my NACWA board members and EPA on March 4th. And then we've also got presentations to town councils. Weathersfield, we just presented on the 3rd, and we're going to West Hartford on the 13th. Something I'd like, I got a lot to talk about, but I'm just going to focus on these two very important issues. I sent an email out to all the town managers and the commissioners and representatives talking about two specific issues, and one of them is the integrated plan, and the other one is the landfill. I'm not going to get into the details of those emails because they're very long, but I do want to make a point. In some of my discussions with some of my DEEP counterparts, they would argue against my position in a couple of ways. I made a very important point that the MDC is the only utility, wastewater utility in Connecticut, that has spent $1.7 billion on the clean water project to date, and we have to spend another $1 billion to be in compliance. So we believe that we're overregulated in comparison to other utilities. They would argue that, well, New Haven and Bridgeport and Norwich all have consent orders, which is true. But let's compare apples and apples. The MDC has a $2.6 billion program, We've spent $1.7 billion since 2008. New Haven has a consent order, 2009. They have a 2-year level of control. We have a 1-year level of control. They don't have any eliminations. We have 9 of our overflows, the North Branch to the Park River and Franklin Avenue to the Weathersfield Cove, are elimination. Elimination costs a lot more money than 1-year or 2-year level of control. But their program is around $550 million. To date, they've only spent, and I don't even know what the number is, but I know what they've built. They've built a 5 million gallon CSO storage tank, and that's all. Bridgeport has a 1-year level of control similar to us, but they don't have elimination as we do with the Weathersfield Cove and the North Branch. Their projects is roughly $585 million. To date, they spent $30 to $35 million. Norwich, they don't have a level of control, but they've got a number of gallons that they have to remove, roughly 103 million gallons of CSO they got to remove. That budget is estimated at $270 million. To date, they haven't done anything. So my point is true. The facts are the MDC is the only utility in Connecticut that has been mandated to spend. We're averaging $119 million a year for the last 13 years. And like I said in my email, no one's even come close to spending that, and those are facts. I've compared ourselves with Boston. So I've said this numerous times. Boston is about the same size as the MDC. There's 600,000 customers. We're 400,000. I'm sorry, 600,000 population served. We're 400,000 population served. We've got 102,000 customers. But I've compared ourselves because in the size, they've spent about $500 million on their CSO program. Again, MDC we will spend 2.6. Deep would argue and has argued to me that they're referring to MWRA has spent $900 million to date. Well, here's the difference. Boston is not MWRA. Boston is Boston. Boston is a city, an entity that owns its own utilities, water and sewer, and they have a mandate of $500 million. MWRA is a separate entity. MWRA is a regional authority that serves 60 communities, including Boston. So they are actually serving as like a wholesaler, like Mattabasset is for us in parts of Rocky Hill. Towns send the sewer to MWRA, and MWRA sends the water to these towns, but the towns own the infrastructure in their town. So MWRA comparison to the MDC, there's no comparison. They serve 60 communities, we serve 8. I compared ourselves to Boston, not MWRA. So I think that's important. The other things that I wanted to talk about was, in my email, I talk about what the MDC owes to our member towns in terms of the groundwater surcharge. And Nick, can you go ahead? So in my email, there was a lot of discussion, and there was an article. Some of the representatives went to a Newington town meeting, and they were basically arguing that our state reps were arguing that that they had talked to Deep, and Deep doesn't agree with our facts, and I outline the facts in my emails. And there's also been discussions about the $11 million, or now 13. So it's 11 million up till 2019, including 2020, it's 13 million. So the argument has been, well, we don't really want to talk about that. We want to talk about the water rate. Well, this is an example of if the MDC received the $13 million in 2020 of what we believe Deep owes us, and not MDC, but our 8-member towns. The yellow shows this would be the ad valorem charge to our towns. So we billed our towns 51 million and change. We would have billed them 38 million. The smallest revenue back to our towns would have been Rocky Hill at about $800,000. But Hartford and West Hartford would get back approximately $3 million. So it goes from $800,000 all the way up to $3 million. And this is real. You know, this is real money. So the argument would be, go ahead, Nick, to the next slide. The argument, and I outline in the slide is, and I'm sorry, my email is, they're arguing about what they're discharging and the fact that we basically arbitrarily raised the rate by 27 times. This is the landfill's bill, okay? So this, here, these 2 meters here are actually the groundwater discharge meters, and this is their actual water meter. So what DEEP would argue is that for years, we implemented this rate, this groundwater rate. It was 10 cents in 2007. We changed it in 2016 to 13 cents. 13 cents. What DEEP would argue is, for years, we were charging the sewer user charge, which is for non-member towns, it's for nonprofits, so state buildings, municipal buildings, churches, anything that doesn't pay taxes. There's no way for the MDC to recoup the ad valorem tax to pay ourselves back for providing service to that piece of property. So we have, and always had, a sewer user charge for nonprofits, and that rate, this is 2019, was $4.64. Okay, so DEEP would argue that in up until 2016, the rate was approximately $2.70, and we were charging the $2.70 per CCF for this groundwater. And they're right, that was wrong. We didn't understand that until 2016, but really what we should have been charging DEEP was exactly what we had, which was at the time 13 cents for everything. And as of 2019, we changed and created a staggered rate. So now the first 25,000 gallons is 13 cents, the next is 7 cents, and the next is 5 cents. So that took their 90,000 average gallons per day, and instead of it being a $4 million bill, it's now a $2 million bill. But what they're making the mistake of in their argument is that they're saying that we took the sewer user charge, which was $2.70 approximately in 2016, and basically changed it to this 13 cents. The answer is no. There was always 2 rates, 2 different distinct rates. We were charging DEEP the wrong rate. And we didn't go back. We didn't go back in time and say, we found this in 2016, but you should have been paying it in 2007. We said, only moving forward, we're going to make these changes in your bill, and we're expecting you to pay this charge as everyone else pays. Now, so this monthly total bill is approximately $178,000. Right now, we're only getting about $170,000 total for the year. Nick, give me one more. So this is Pratt & Whitney's bill. Now, Pratt & Whitney has a lot of water meters, so this is just their groundwater slide. But just to show the difference, the Pratt & Whitney has multiple ground meters, and they're charged the same thing, 13 cents. My point is 13 cents for the first 25,000, 7 cents, and then 5 cents. So they're getting charged exactly what we're charging DEEP. The bill is approximately $225,000, and they're paying it. Nick, if you go to the next slide. There's 10 companies here, all that are paying this rate under this structure. And the challenge that we have had has, and Pratt & Whitney is one of them, we didn't realize until really 2016, give or take, that they were even discharging stormwater and contaminated groundwater to our system because DEEP issued them a permit, as I referred to in my email, an individual permit, without our knowledge and understanding. So we didn't even have the opportunity to tell Pratt & Whitney, hey, you need to pay this rate. Triumph, same thing, 2014. We didn't even know that they were discharging. It wasn't until we got a call from Triumph, who actually bought out another company and said, hey, what's going on with this permit? And we said, what permit? And realized this individual permit was issued without our knowledge, without our signature. Deep issues this permit. This is an individual permit issued by Deep. All of these get a permit from Deep. On the bottom of the permit, Deep's forms, it says POTW, which is Publicly Owned Treatment Works, which is us, or any wastewater treatment facility. We have to sign off on that. So when Deep would argue, we didn't know that you had this charge. Well, every one of these permittees are getting charged this rate because of a permit issued by Deep. The permittee is required to get our signature. We sign it if we're aware, and then we're charged this 13 cents, at 10 cents, 13 cents at the rate. So this is just trying to counteract some of the comments I got back from Deep over the last number of weeks regarding my email. And this is where this goes, I don't know, but the important part is that we're not charging Deep anything different than anyone else on that chart. And I think I'm going to leave that, Mr. Chairman, for
Does anybody have
everything
any
else.
questions? Alan?
Yeah, thank you, Mr. Chairman. Is there any reason that we cannot invite someone from DEEP to come here and make a presentation in defense of this situation?
We have. We asked for them to come to a board. I can do that again, but we have asked for them to. We actually invited them. We'll publicly invite them tonight.
Well, this is being litigated.
Yeah.
As a result, the Attorney General had recommended that they not come. Wasn't that it?
Yeah, we had invited them, I think it was 2018, in fact. We invited them for the first time before the litigation commenced. I believe it was just after we filed with the Claims Commissioner. At first, the commissioner at the time, Commissioner Klee, had a scheduling conflict, and that was the reason why he couldn't come. And then I think he was advised shortly thereafter by his counsel, by the AG's office, because of the pending state claims commissioner claim not to appear, and then subsequently there's been litigation. So you can ask, but he's not going to, or
Well-
she, excuse me, is not going to be permitted to show up.
We did have a meeting initially at DEEP with the commissioner and the commissioner's legal
In the AG's
team.
office, yeah?
No, the AG's office wasn't there.
Well, that's the
That was
commissioner.
well,
Oh,
yeah,
the
they're
in-house.
embedded,
Okay.
the embedded.
Right,
We had
gotcha.
two separate.
legal. Right, and I think, Buddy, you and I were at that meeting.
At the Commissioner's office?
Commissioner's office. right.
Yeah.
Yeah. And then we ended up, Bart Halloran and I met with the commissioner, the Attorney General's office, the OPM secretary, who else was there? The governor's lawyer. There's a fourth party there. I can't remember who it was. And we had, I think, 2 meetings with them.
Yes.
And got nowhere. We argued around the circle relative to what the issue was, and they were claiming we would create a major environmental hazard if we didn't allow them to discharge into the sewer, which wasn't the argument. It was a question that they had to pay as everybody else did, and we went through that. And then ultimately, they ended up in an injunctive action. So we were out of that discussion. The injunctive action was filed, and Mr. Stone can explain that to you.
Yeah, if I may, and this is part of the report that we were going to give next, but I'll get right into that. We did file the injunctive action back in late 2018, January 2019. It was met with a motion to dismiss from the state on the grounds of their claim of sovereign immunity. We had briefing schedules, reply briefs, surreply briefs filed. Oral argument was in John, I think it was October of 2019, John, was it? Yeah. And then we received a decision from Judge Scholl on January 9th of 2020. We have, and I think I informed the board last meeting, we have filed an appeal of that decision. There are parts of it which we think the judge, with all due respect, was incorrect on, and so we filed an appeal that's in its infancy stages at this point. We have filed a preliminary statement of issues for the court as required within 10 days of filing the appeal. And before any briefing schedule gets in place or any briefs are prepared, there has to be a status conference or settlement conference with the court. So we're waiting for that to be planned or scheduled. The second cause of action that's been filed relates to a separate claim for injunctive relief brought directly against the Commissioner of Deep to try to get around the sovereign immunity defense that's been posited by the state. That is pending. There's also a motion to dismiss on that case. We're right in the middle of the briefs on that case. We expect that to come up for oral argument within the next 30 days. So we'll obviously keep you informed on what happens with that case. On the Claims Commissioner side, and I know you've received emails from my office over the past several weeks. On the Claims Commissioner side, the Claims Commissioner had 2 years in which to render a decision on the matter. That 2 years expired on December 13th, 2019. They asked for an extension of time. We were not willing to give one. Because the 2 years has expired, now the legislature will get a report. I believe it's due today, in fact. It's within 5 days of the opening of the session, from the Claims Commissioner, in which she indicates what cases have gone the 2-year limit, and she was not able to get to them for whatever reason. She was not able to address the claim. So the legislature will have that probably by the close of business. By 5 o'clock today. We have submitted to the legislature your legislative delegation from each of your member towns, as well as the General Assembly as a whole, in particular the chairs of the Judiciary Committee, 2 proposed resolutions. The first resolution, which the General Assembly has the authority now to act upon, is a resolution to validate the claim and direct payment. The second resolution is a resolution that would release the claim from the Claims Commissioner's office and give the MDC the authority to sue, which would get around that sovereign immunity defense that we've been butting up against. There's 2 other options. One is they could give the Claims Commissioner an extension. The other option is that they could deny the claim on the merits. Obviously, we haven't asked for either one of those things. We have met with the chairs of the Judiciary Committee. We're hopeful, if not optimistic, that they will act in our favor on one or the other. Obviously, we prefer payment, but the right to sue would be worth pursuing as well. You have, and representatives of your towns have also weighed in on that for us, and I've been hearing from legislators who have said, we've heard from either someone from Newington or someone from wherever, but they've stepped up, understanding the enormity of the matter and the fact that they stand to benefit. They have stepped up and weighed in our favor. So, again, I'm optimistic that we'll get some result. Obviously, we need that before the first Wednesday in May, this being a short session.
Any questions? Buddy, then.
So you referenced the meeting that we were at with Commissioner Klee and practically his entire staff. I think I counted 18 people counting him, and there were 5 of us there. And that was in May, I think, or something. And then later that year, we talked about the possibility of closing a landfill, and sort of terminating the discharges there. So the issue, I think, Chris did a great job just now of explaining it. It's sort of technical, but the issue is really that DEEP is both the regulator of this, what to do with this contaminated materials or whatever, and the violator. They're the ones that are violating their own regulations at this point. And if we, as the chairman was saying, if we attempted to stop receiving this material from them, that we might put ourselves in position of becoming a violator at the same time. The issue for us is that right now, we're not, and, you know, asking the legislature to sort of, they're not going to adjudicate this, they're just going to give us a path to go down one way or another or something, that EPA is really involved in this. So I believe that on the way from the landfill to the treatment plant, there are 4 CSOs. Somebody here from engineering, tell me if I'm right around, at least 4 CSOs. So 4 combined sewer overflows. So if there was some sort of storm event that was significant, and it caused those CSOs to dump out, they'd wind up in the Connecticut River. Maybe one of them's in the Park River, gets pumped into the Connecticut River anyway. So they're all going to wind up in the Connecticut River. And at that point, I guess we'd both be liable, both DEEP and the MDC might be liable for that. And so I think that, you know, the issue is really that not, you know, so much historically, as Scott pointed out, like what they were paying before, what they need to pay now. The issue is, to me, a public health issue, that if we don't do something about this, there's going to be a problem with, there's going to be a problem with this at some point if we don't do something about it. What's coming out of that landfill is almost pure ammonia. It's, you know, if anybody's wondering if whether or not it's really dangerous or not, I'd invite you to go over there and we'll fill up a little 8-ounce glass of that stuff and you drink it and I'll drive you to the hospital. So, it's that serious, you know. So I think to let it go on for this much time doesn't respond to the fact that it's a real public health issue. And I hope that if the legislature is going to act, that they'll do it soon, to either give us permission to sue or try to set something up where we actually work with them again. But they never really spoke to us again after that meeting in May, and they still haven't. It's just Scott occasionally, you know, responding to some of their issues where, you know, like you brought up tonight. But nobody's really talked about what the ultimate solution is. And they could, I think, they could treat it there on the site themselves if they wanted to.
Truck it.
A treatment plant for 90,000 gallons a day could basically be prefabricated, put on a back with trailer truck and sent over there. And they could be doing it themselves if they don't want to pay us. I just don't think that they want to be in the business of doing that, and I don't blame them. So I think that it would be easier for them in the long run to work with us and get it taken care of. But go ahead.
Commissioner Sweezy.
Yeah, just
Sorry.
in Rocky Hill a few weeks ago when Jellison, Chairman DeBella, and myself met, the next day, some of you may have heard this already, I said it last week, but the mayor of Rocky Hill, Murata, called me and asked me what, you know, she could do. She understood that the state owes us money. She understood we need the integrated plan, and we also need the funding to go along. So we waited a couple days. Scott sent out a 4-page email to, like he said a few minutes ago. I met with the mayor. We put together a letter basically saying on behalf of the Rocky Hill Town Council, actually I have it on my phone here, it says, on behalf of the Rocky Hill Town Council, we write to urge you to support the 2 recent Metropolitan District efforts, namely the integrated plan and the $13 million. Anyone, I mean, this is so important, like Chris Stone said, he's hearing from representatives. The town of Newington has put together a letter, voted by the council. The town of Weathersfield has, the town of Rocky Hill has. The letters are going out to our state senators, our state reps. I mean, the city of East Hartford could have, if we collected this money, could save $1.5 million from $6 million to 4.5. Rocky Hill's an $800,000. The city of West Hartford, $3 million reduction. So it's so important that you get to your mayors, and we need the full funding in the integrated plan also. We don't just need the change, we need the funding. We can't lose that 40%, I believe.
40 to 50%.
So, Scott, Chairman DeBella, I mean, they did a great presentation in Rocky Hill. The mayor understood what we were saying, and she came on board within a few days. We wrote a letter. It's gone out to our state senator, our state rep. We only have one state senator, one state rep in Rocky Hill. But it's so important that every other town comes on board and talks to their mayor or council members to get them on board. And if we could get every state rep, and Chairman DeBella went to the city of Hartford, he was able to get the city of Hartford, they're coming on board with that, or at least the mayor, I'm not sure exactly, I don't want to misstate myself, but the mayor's coming on board. So we could have a lot of state reps and a lot of state senators supporting us getting this money. And the two plans Chris said, I mean, that's what we're going to need. We're going to need votes over there to make this happen, so.
Further questions? Alan?
Yeah, thank you, Mr. Chairman. I just wanted to bring the discussion back to the comments from Attorney Stone and to thank him for that detailed explanation. And you referenced this expected report from the Claims Commissioner. And so my question is only this: can we then take that report, circulate it to our district's state representatives and state senators, and perhaps get a little action from them?
Yes, we'll get that for you, and we'll distribute it. I believe it's either today or tomorrow is the deadline. It's 5 days from the start of sessions.
That's
That was
fine.
last Wednesday, so it's today or tomorrow, but we'll get that to you.
Further discussion? I'm sorry.
Thank you, Mr. Chairman.
Commissioner Curry?
I've been in contact with my legislative delegation, and, they hear us. In fact, they told me they're a little tired of hearing from me. But the fact is, they also have had communications with DEEP. And of course, they're hearing some conflicting information. They're not sure which is correct, which part of each is correct. One suggested, well, it's pretty easy, just put MDC and DEEP in a room and work it out. But my question is, because we're in pending litigation, we really can't have such a meeting that would also include legislature delegations from.
The legislature can have,
Participate?
legislature can have a meeting with,
They can meet with, obviously, and they've met with DEEP, and they have met with us separately. You're not going to have a meeting requested by a legislator with both of us in the same room. We're not going to do that, and DEEP's not going to do that. But all along the way, since goes back to 2018, mid-2018, we've been willing to sit down with DEEP, have on a few occasions with no result. And if the legislators want to broker a meeting amongst the principals, which would be in furtherance of settlement, it'd be confidential negotiations, confidential statements. As soon as you get some third party in the room, you lose that. So the third party would be the legislator. If they want to broker a meeting and put us in a room and have us try to negotiate a settlement, just as we have before, we'd be willing to participate in that, I'm sure. So
We did that
so
with CRA.
far, it hasn't happened, and you're right, that's a good point, Scott. We did that with CRA. We ended up achieving a resolution. Or if they want to go through some formal mediation, we'd be willing to do that. I mean, we're not interested, with all that we have going on with DEEP, we're not interested in merely litigating the issue. It's not going to solve the issue for our towns in any immediate sense. So if we've tried, in fact, we went so far, you went so far, as to modify your ordinance where this discharge fee applies. You modify the ordinance to reduce the burden. It wasn't just for DEEP. There were others that were taking advantage of that. But you've attempted to do formally what perhaps the legislatures would like us to try to do informally, but we'd be willing to participate in that.
As a follow-up, do we have any, does MDC have an obligation, and I raise this question because in the paper a few days ago, there was an article about the Farmington River that said, if you're catching fish to eat, only eat one fish per month, but don't eat any if you're pregnant. So one fish per month is, because of the PFAS at the airport. Knowing what's flowing into the Connecticut River from the landfill, are we under any obligation to ask that Connecticut River be tested below those spills and to notify?
So Commissioner, to your question, the state of Connecticut DEEP and the state DPH, who are the regulators on water quality and illegal discharges to water courses within the state of Connecticut, those two entities are focused on the airport. They're the ones who said to the airport, if you illegally discharge PFAS to the MDC's sewer system, again, you will be fined $25,000 per occurrence. The two regulators that are in charge of protecting all of us has yet to talk about the PFAS coming from the landfill. Now, here's the problem. The PFAS is coming from the into the Connecticut River in two ways. It's getting discharged to our pipe, and then it flows to the plant, and then because we have no way to treat it, it gets discharged to the river. And then the other way it is that the seepage of the way in which the landfill is built and the way the dike is built, the dike, as I presented at one of our board meetings, the water is allowed to flow through the dike, right? That's why there's footing drains that collect the water that come from the water side onto the land side of the dike, and then it flows to the discharge point, which is the North Meadows Pond, which is the drainage system for the storm system. So if the landfill is roughly 100 feet higher than the dike, when the landfill is full of water because of rain, you would think the hydraulic pressure would be able to go the opposite way, right? Be able to push water from the landfill into the aquifer of the Connecticut River. So why isn't DEEP and DPH concerned about DEEP's argument? They have said publicly in the Hartford Courant, the number one source of PFAS is landfills. But yet we've heard nothing from the regulators about PFAS and coming from the landfill into our pipe, into the plant, and then discharged. I agree with you 100%. The question is, why isn't DEEP concerned about that PFAS, but they're concerned about the PFAS coming from fire protection foam that occurs once every 25 years? When the PFAS is coming into the Connecticut River every day from the landfill.
And I ask because on good days, my wife and I walk the river, and we see, every day we see fishermen. Summer sports, they're catch and release. Some are catch and keep, because they are. Some are catch and keep because they need to supplement their income. But they're taking this fish home and they're eating it, and they're unaware of what's happening to those living creatures that are in the Connecticut River.
We agree with you.
All right.
But I believe it's DPH and DEEP's regulations. If you go to DEEP's website or DPH's website when it comes to fishing, they clearly show on their website, for example, PCBs, forget about PFAS, PCB oils. They clearly tell you on DEEP's website where the fish are and what fish you shouldn't eat. And they're very systematic about PCBs and how many fish you should eat over a given year or given month. But we agree with you. They should be the ones telling the public and making them aware south of the Farmington River.
Going to come Michigan East, Flint. Any further discussion? If not, could you proceed with your report?
He's done with his.
You're
I'm good.
finished, okay.
Yeah, and I think, yeah, we're on.
Yeah, and that's all, I don't have anything more for our report.
What you received from Mr. Stone was what he just gave you, was coming next, so.
Yeah, the real important, another important pending matter, excuse me, is the item number 9, which we'll get into
Yeah.
when.
Okay, item number 9, potential settlement of pending litigation, pet soil and MDC, possible executive session. Is there an executive
Please.
session? Do you want to take the executive session at the end?
I have outside counsel here, Mr. Chairman, so
Okay.
if you don't
Okay.
mind. I don't think it's going to take too long.
Right. Is there a motion to go into an executive session?
Move that we go into executive session.
Been moved and seconded. All those in favor, please signify by saying aye.
Aye.
Opposed? Who do you want to stay? Okay. Where are we going now? Go ahead, Ray.
Water Bureau approved A, B, and C at its last meeting.
Are there any questions? These are service installations, licensing on the reservoir. No further discussion?
Thank you, Mr. Chairman. My only concern is, and while I'm not asking they be separated, state of Connecticut is one employer. Lots of different agencies, but still one employer. We're in litigation with that employer. You know, approving anything for the state just kind of,
Understand that.
I will support this.
They're easements, right?
Yeah,
Yeah.
the easement.
Easements. Further discussion, no further discussion. All in favor of A?
I'm sorry, Bill, it's consolidated, but we need somebody to move all three of them.
I'm sorry. I asked without objection that they be consolidated, and there was no objection. So they're before us.
Oh, you
It's all
want somebody
three.
to move all three?
Well,
Yeah, I moved all three.
He moved, and I said without objection
I
that
missed the
that it would
moving
add.
resolution.
Okay. This would be for A, B, and C. It was moved to consolidate all three of them together. All those in favor, please signify by saying aye. Aye. Opposed? 11, Board of Finance, consideration and potential action regarding reallocation of certain bond proceeds. Is there a motion to adopt?
So moved, Mr. Chairman.
Second?
Is Chris going to talk about this? Chris?
Okay.
Buddy?
Yeah, I would say that at the Board of Finance meeting on February 3rd, this motion was passed unanimously. Go ahead, Chris.
We did have a conversation about this at that, at that meeting. This goes back to projects that began in, some that began in 2017. And some of you may know that when we borrow money for clean water projects, we do so in the form of short-term interim funding obligations. And then when we were able to draw that money down from the state, as we need it, we draw it down, and then we permanently finance that in a project loan obligation, which is a 20-year repayment. On our GO projects, we have, you can see in the audit, there's 4 pages of projects listed, and the $110 million was, at the time, an estimate of what those projects would cost. And I believe there were over 100 projects involved, but inevitably, when you complete projects, you find some projects, even based on best expectations, were either completed or not completed. I think the example that Susan gave me most recently of a project, we bonded for a project on Oakwood Road where we were going to replace a pipe. It turned out that we were able to line that pipe, therefore, the funds borrowed for a permanent financing were able to be freed up and reallocated to other projects. So of the $110 million, this represents about $2 million in projects that were reallocated for reasons like that. I think we could actually, there's probably a story about each one of those, whether they went forward or they didn't, but it's a relatively small percentage, and it's one of the reasons why when we borrow for CIP projects, because we can't draw money down like we do from the state for clean water projects, we try to be very careful about sizing those borrowings and being pretty sure we're reimbursing ourselves as much as possible for things that have already been done. But obviously, we're trying to minimize our cost of issuance. So I think that's.
Chris, can you just clarify in these circumstances, so we've done a lot of things to try and avoid this from occurring with new procedures. For example, we're asking staff, engineering staff, when we look for monies, instead of look for the entire authorization from the board, we're looking for just the design piece up front, so we have a real guesstimate estimate prior to coming back to the board and getting, a wrong amount requested. But also, this money is not actually, in most cases, not actually bonded. It's just an authorization, right? So we're changing the authorization, but we actually hadn't bonded the money, and it's not cash sitting there.
Right, so there's more than one explanation here, but I think one of the things that we're doing in coordinating better on projects going forward, we're trying to minimize the amount of costs that we incur when we borrow, so that we don't want to be, there was one year when the district was in the market 5 times in 1 year, and obviously the issuance costs are very considerable. So to the extent that we can reimburse ourselves for costs already incurred, we lessen the instances in which we have to reallocate. But I would say, this is a fairly small reallocation to have to do, but in the grand scheme of things, you don't always have perfect information about what you're going to need to spend and when you're going to spend it. So you make the best judgment possible, and you try to minimize the potential for these things to occur. So this is a relatively minor reallocation when you consider it was a $110 million set of projects.
Commissioner Salimi?
Yeah, I think I just would add, I think, to what Scott was saying, was that these are authorizations, so the project hasn't actually been done yet. They're authorizations to do a project.
Or may not have been bonded yet.
Yeah, and you said, like, for instance, one of them was sort of the subject of a value engineering thing, and said, wait a minute, you know what, we can reline this pipe, we don't need to replace, we don't need to excavate, we don't need to rebuild this, we can reline this pipe. And so the actual allocation goes down because you're only relining it. And then there's a balance of funds there that from the authorization, that what we're doing here is moving it to a project that needs the funds rather than leaving it in there and then just
Exactly.
collapsing it later.
Yeah.
So rather than ask for $5 million in our CIP request at budget time, we're going to ask for the design piece first, so that we can do our due diligence in the field and not have to come back and say, well, we didn't need $5 million, and now we need to reallocate it to some other project.
Yeah, you can use the
To avoid
design
those
to
costs.
do
Right.
to basically improve the quality of the estimate to
Yep.
do it. So.
Further discussion? If not, all those in favor, please signify by saying aye.
Aye.
Opposed? Okay, item number 12. Committee on MDC Government, consideration and potential action regarding, we got to take these separately. A, appointment of legislative consultants. Is there a motion?
Move it.
Second.
Moved and seconded. Discussion?
Mr. Chairman, it was the case that this item passed unanimously after a brief discussion.
Any discussion? If not, all those in favor, please signify by saying aye.
Aye.
Opposed? Item B, revision of 2020 non-member town capital improvement surcharge.
Pass.
The action, is there a motion to adopt? Moved and seconded.
Again, this item was passed unanimously after a little bit of a discussion.
I
Commissioner.
want to understand from the administration that basically I looked at it and most of it goes down. I know the bottom line, what we receive will be the same. Simply distribution changes. The question is that why did we select, if we have total choice, that 2-inch pipe in Farmington should go up as much as it does?
how many people or how many customers are impacted in each case. Most of other people will be charged less.
Yep. So, just to clarify, so the mistake that we made was we did not bring the proper chart in the budget process. So when you look at the resolution, you're looking at what was approved last month. And what we're proposing today, and it shows a significant difference between the 2-inch meter, right? But that's really not the issue. The issue is, if you look at 2019 rates, there's still a major increase in the 2-inch meter. It's just, it's more under this proposal. But here's the reasons why there's difference. Every town, non-member town, pays 100% of the capital investment in that town. Every town investment is different. And every town has different, like, for example, in Glastonbury, we might have 3 customers with a 2-inch meter, and in Farmington, we might have 10. So every town has its own calculation because they have to pay, there's only so many customers in that town, and they have to pay 100% of that CIP, so it gets divided evenly, but based on meter size and based on max flow within that meter. So every town's a little different.
I understand that. What I want to know is that when you choose particular size, what was the logic behind it?
AWWA standard. So the industry says a meter.
The Senate, what is hydraulic?
Well, AWWA is American Water Works Association, so they are the standard, just like NFPA is to the fire protection system. They're the standard of the industry for water meters. And they basically say that your meter, if you're flowing X through that meter, you should be using parameters that meter can properly record. And if you're using 1,000 GPM, then you should be using a certain size meter. Versus too small, too big, you're not going to properly capture the flows because every meter has its own efficiency based on its size and its flow. So the standard is based on the industry by AWWA.
Rich?
And towns have no input, or I'm looking from perspective of public relation, that you please 8 people and maybe 800 people with 2 meter are displeased.
Yep.
So did we take
So
a
we
look
will-
at the numbers?
When the board approves the rate, we have our letters already drafted and written, and they will go to the town manager, and we copy the town manager and our commissioners, our non-member towns, to explain exactly how the rate was calculated, what it's based on, meaning how much capital investment was made, in what year, what projects, very specific information so that they can see what the rate is for its town.
Thank you.
Rich? Commissioner.
Excuse me, the way I read it, it looks like in towns outside the Metropolitan District for which capital improvements or layout of assessment projects are constructed. To me, it doesn't seem to address existing. It looks like what's going to be a capital improvement or new construction. I get confused when I read this.
Do you want to talk about that?
It's for any project that was completed, so it has to be completed, it has to be accepted by the MDC and the board. So once that project is completed, then we are able to charge the CIP for that project, and it's accumulative, right? So if you're bonding for 20 years and you have so many projects, as you pay off bonds, then a project drops off.
An existing built project that has a 2-inch meter will get this new charge.
If we spend $15 million in Glastonbury on pipes, infrastructure, new improvements, whether it's pump stations or it's water main on Kimberly Lane, that investment, once that project is completed, everybody in the town, so there's 5,800 customers in Glastonbury, their CIP charge, and they have that CIP charge on their bill right now, and that new project that gets accepted will be the debt service will be added to that CIP charge in that town.
Oh, just simply, projects built, this is the new rate for an existing project also.
It's the
Existing
meter.
2-inch meter.
We're using the meter size, Commissioner, to decide how much you pay of the CIP cost.
Understand. One other question. If you're using the CIP, how come certain areas only go up to 4-inch meter and certain areas go up to 6 and 8-inch meters? Why isn't Glastonbury stops at a 4-inch meter? Is there a reason?
There's no 6 or 8-inch meters
Yeah.
there.
In Glastonbury?
Yeah.
Okay. And was there one last question. Was there a public hearing?
Yes.
Okay, thank you.
We had actually 2 public hearings because we made a mistake, and so we had to correct that.
Recalculate and have another public hearing.
Okay, thank you.
Further discussion? Commissioner?
Thank you, Mr. Chairman. Just to follow up to that question, if Glastonbury doesn't have 6 and 8-inch, and tomorrow they do, what rate will we charge them?
I apologize. My attorney was whispering in my ear.
It would be calculated for the 2021 budget.
For the
It
next
would be
budget.
calculated for the next budget for 2021.
In 2021?
Yeah, it's based on the capital improvement that will be done in the 2020 fiscal year. If there's no meters in the larger meters, they wouldn't be in that calculation.
I guess my question is, why don't we set the rate for the towns for all the different diameters of pipes, whether they have it or not?
Because the way it's calculated, it was based on the volumetric, the hydraulic capacity of each meter within each town. So if you have 10 6-inch meters in one town, and then you drop down to 5, that's going to affect the rate. So the amount of flowing through those different size meters will affect it.
Thank you.
Further discussion? If not, all those in favor, please signify by saying aye.
Aye.
Opposed? Aye. What's that? Is there some? Is that? Yes, okay. What item?
13.
Item 13, Personnel, Pension, and Insurance Committee, consideration and potential action regarding pension plan amendment, one-time retirement payee. Is there a motion to adopt?
So move.
It's been moved and seconded.
Mr. Chairman, this was
Is this
approved.
Buddy? I'm sorry, is it Al?
Yeah, Mr. Chairman, this was discussed and approved in PP&I.
Discussion, but that was the one-time payment?
One-time payment, yes.
Yeah, which we had to bring back and you
We've already
recalculate.
voted on it twice. We had to bring it back. I
What's it?
believe, Bob's here.
What's it,
Let
I'm sorry,
tell
Bob,
you.
he's up there, I didn't see him.
Right.
Go ahead, Bob.
Okay, so this goes back to our pension plan. We don't have a cost of living adjustment built into the plan. March or May of 2018, on behalf of the retirees, a request was made. Last time we did such a review and such an adjustment was 1998. So we bounced up proposals all the way to the full board, and then they bounced back to the Personnel, Pension, and Insurance Committee. So November, they actually settled in on a resolution and approved it, and it would be based on the last date of adjustment. So it read, people that retired before January 1st, 1999, and they had to have $1,500 gross monthly or less. So based on the census that we used, January 1st of 2018, we saw that there were 22 people eligible, 22 retirees. We excluded beneficiaries, we excluded alternate pays, we excluded those types of files. So in the process of fine-tuning that, we discovered some people had died since that census was published through Milliman. So right now, we're at 19, so it'd be $1,000. It doesn't go towards their pension. It's a one-time cash deal only. We're set to go. It would be coming out of the pension fund, $19,000.
Discussion.
Thank you, Chairman. Just to put it in perspective, you've got 19 folks. If their buying power was $18,000 in 1999, with the average cost of inflation at over 2% a year, that buying power today, 20 years later, is like $8,200. So the $1,000 it's really, it's nice, but I know the members of PPI have agreed to come back and revisit this. And I think you're all given a handout tonight listing 10 or 11 more retirees that fall under 1,600, 1,700, et cetera. And I'm hoping we'll have a long-term, better long-term solution to addressing the needs of our retirees. We felt it was important we stay with the defined benefit plan, or a hybrid maybe, which I concur with. But 20 years later, these folks can use a little assistance. And I think we owe that to them.
Commissioner Hall?
Well, I agree. It seems like it's a nice thing to do. Typically, in contracts, if they're saying we're not going to give a COLA, there's some other benefit that they might have received that could have more than, compensated them over that same time period. So I would think we would need, or maybe it's already been done, we've gone back and examined those contracts to see, was there anything that they received in exchange for not getting the COLA?
I think the only thing they got was a watch at the
Well,
25 years.
yeah, well, actually, the one thing our retirees did receive prior to the last change was when you retired, obviously you receive medical. And when you retired, whenever that is, your premium of your medical is frozen. Correct me if I'm wrong, Bob, right?
Yeah.
So if you retired in 1999, whatever that premium was, a family medical plan today costs the MDC approximately $25,000. A family medical plan in 1999 probably cost a lot less than that. So whatever that premium was, it's frozen at time of retirement, and that's all you pay. But as you age and you're in retirement, the MDC picks up the delta between what you retired at. So there is a benefit that our, not to your point, Commissioner Curry, that it probably doesn't compensate like the state. They have a COLA, and they've been averaging a 2% COLA for a number of years. But there is some benefit of our retirees when they retire on the medical premium.
And just to elaborate, once they become eligible for Medicare, the district reimburses the cost of Part B, and that's where the recent negotiations, we've stepped that down for new employees. It won't be available for dependents or spouses once they retire in the future. But that's a significant benefit.
Commissioner Sweezy?
Also, what Scott was saying, we also gave that benefit to the spouse.
They took that away from the new
The
employee.
spouse also got the benefit, which in the last contract, we also took that out on new employees. New employees, when they retire, their spouse will not get that.
The surviving
insurance,
spouse.
Which is going to be about a $42, $45 million savings to the district over the next
25 years.
25 years.
Good.
Further discussion? Not. All those in favor, please signify by saying aye.
Aye.
Opposed? Item 14, Bureau of Public Works, consideration and potential action regarding request of Connecticut Light and Power doing business as Eversource for an easement over district property located at 231-255 Brainerd Road in Hartford. Is there a motion to adopt? It's been moved and seconded. Rich?
We had this on our agenda on the 3rd of February, and it passed unanimously by the Bureau of Public Works.
It's an easement across Brainerd Road, right? Discussion? If not, all those in favor, please signify by saying aye.
Aye.
Opposed? Okay. Let's see, that's the end, huh? Recommendations. Item 15, opportunity for general public comments.
There's some calculations, but I just wanted to leave this if anybody is interested. Hello, Val Rossetti from Bloomfield. I wanted to come back this week because last week there was some discussion about drought regulations and the Niagara bottling discounts. I just wanted to clarify that although the MDC can talk to Niagara or plan with the DPH, your own brochure states it has no authority to prioritize water use during drought triggers. It also states, which is true for the water supply plan, that there wouldn't be any mandatory industrial limitations mandatory until the reservoir was at 10% of its level. So a lot of folks have trouble with the idea of even being at 75% drought trigger, being, getting down to 53 and being told don't water your lawn, don't shower, municipalities cut back, but still we have up to almost 2 million gallons of water being used to bottle and ship water out of the watershed. So normally when water is transferred out of a watershed, it needs a diversion permit because it's leaving one watershed to another. But when you ship it out in bottles, that's not true. And if the MDC, I would just say, if we're so certain that there will never be a drought where residents are subject to drought provisions, I don't really understand why it was such an incredibly vigorous lobbying effort against state regulations, which just would have said for water bottlers there should be a renewable permit consistent with the safe yield that gets adjusted over time with climate conditions, and that if drought triggers are hit, water bottling shouldn't be shipped out of state. That's one issue people have with the Niagara discounts. I don't have much time to talk, so I wrote this up, but it's been presented publicly that this is a great deal because residential rates will decrease by 10 cents per CCF. But what's being neglected here is the income that you're potentially losing by giving this discount without a necessity for it. So for your information, if you had voted for this discount last year, you would have actually lost the MDC money. Niagara Bottling got a permit for its third line in October of 2018. The line's up and running. There are no permits for a fourth line. So you run the risk of actually losing money with this discount if they don't increase their water bottling. And when you look at the actual revenue that the MDC could gain without a 20% discount for water and an up to 75% discount on the Clean Water Project charge, it's $4.7 million versus $2.5 million with the discounts. So you're essentially giving what I consider a corporate giveaway of about $2.5 million every single year, which may not be necessary and is likely not possible. And I'm using the figures that Mr. Jellison used in developing the 10-cent discount, which is that Niagara would somehow...
Time is up. Please conclude your statement.
would increase their water use by 1.2 million gallons a day, which I don't think is likely, but consider the corporate handout that you're giving and you're basically pinning some of MDC's revenue hopes on the water bottling industry. Thank you.
Thank you.
Judy Allen, West Hartford. I submitted some written comments, and I did it in a hurry, and I didn't edit well, so it's not my best work. I'd like to speak about the proposed discounts for Niagara. So far, Niagara has been using water that can be handled by 2 lines of bottling out of the possible 4 lines they would need to use in order to use the maximum 1.8 million gallons of water a day. The amount they use varies from month to month, but overall, they have slowly been using more. There is no evidence that Niagara needs any incentive to use more water. If you provide Niagara a discount on water they intended to use anyway, MDC loses revenue. Niagara is a successful, profit-making business. They do not need discounts to make a profit. They will use whatever water they need. They won't build another line just so MDC can sell more water. Mr. Jellison repeatedly says if Niagara was using up to that 1.8 million gallons of water, our rates would decrease by 10 cents. You have no idea if and when a fourth line would be built. Their use goes up and down and will never get to 1.8 million gallons of water per day for an entire year. The 10-cent reduction for water rates just won't happen. But Mr. Jellison says the only way to keep rates down is to sell more water. And we know that's not true. You just reduce the rate by 3 cents by making cuts in the recreation budget. There are many things that affect water rates. For some reason, your staff has been unwilling to look at a rate structures successfully being used by water utilities throughout the country to address the same loss in water consumption that the MDC faces. That's a long-term solution. In the Bloomfield Messenger, Mr. Jellison says, build it and they will come. So we are going to create a rate that will encourage them to come. The MDC has no authority to determine what industry should be encouraged to come to Connecticut, especially one based on how much water they use. In Bloomfield, they may be questioning the wisdom of expanding Niagara as heavy water-laden trucks and their exhaust eats up roads and destroys air quality. Do you want Connecticut's roads and air quality to suffer while MDC creates a mecca for the water bottling industry? What happens when Niagara doesn't use 1.8 million gallons of water a day? What happens if no new businesses are attracted? In the Bloomfield Messenger article, Mr. Jellison says the responsibility is yours, the commissioners, not his. You are the ones who vote. When next year comes around and the rates are not reduced by 10 cents, what will you tell customers? The responsibility is yours. The proposed discounts are unfair and won't solve the problems you hope they will.
Ray?
Yeah, under Commission's questions. Water Bureau, about 3 weeks ago, passed a resolution on economic development rate. We had to bring it back after Public Works passed it a week ago. We adjusted it to what Public Works had. My question is, when is the public hearing going to be set up so that we can move forward with this, up or down, whatever the vote is, but we need a public hearing so we can bring this back in March I believe you need a 10-day notice. I understand John's working on it, but can we get it done?
Yes.
It will be, that's government, right?
Government.
Government committee. John,
Okay.
take care of it.
So we'll get the hearing in the next few weeks?
We're working on a microphone issue at the training center because we expect a large attendance. But the goal is definitely have it done by the end of this month. I spoke to Commissioner Hoffman tonight about dates, and
Good.
it should be available prior to, well, we need a government meeting before the board meeting, so that would need to be squeezed in as well, before the night of the board meeting.
Thank you.
Commissioner Salemi?
Thank you, Mr. Chairman. It's been quite a while now that, I've been listening and reading comments from both Judy Allen and I also have this written comments from Valerie Rossetti. So I appreciate you putting them in writing. And, I think one thing is clear, and I think, Judy, you say it in your remarks, but you didn't say it when you spoke tonight, is that, the real depressing factor on water sales is not the water rate. Our water rate is it's one of the best water rates in the state. So it's not the water rate itself. It's the clean water charge, the clean water project charge. There's no doubt shouldn't be any doubt in anybody's mind that $4.10 on top of our water rate of $3.97 it's more than the water rate itself. Okay, so, and I think that it's not, for me, it's not a question of just offering a discount to a large user. For me, it's finding a way to not charge that if the water is in fact not going down the drain. Okay, so at Niagara Bottling Company, I know you said it's going in a bottle and it's getting shipped out of here. But that's,
Direct your comments to the board.
yeah, but I'm just saying that that's private business. I just want to make sure they understand. I'm trying to respond to what they said. But so it's going on a truck and it's getting shipped out of district. I don't think that makes no difference to me whatsoever. Once we sold the water, we sold the water. We don't have control over it after we sold it. So whatever they do with it, they do with it. But if it's not going down the drain, if it's basically using to water a golf course or a cornfield or something like that, and it's not going down the drain, then we should find a way for them not to have to pay the clean water project charge with that. And just to say, well, we're going to collect less revenue, yeah, that may be true, and that we might collect less revenue for the clean water project. However, I would rather be collecting it in a situation where it's fair, where we're charging it fairly, where it's meaningful, and it doesn't belong on the water rate. The clean water project charge should not be tied to the water rate. And so you have some big users like golf courses or, farms. There's still some farms in the district that use the district water. And other places, where the water is not going down the drain, so it's not becoming an issue for the sewage treatment plant. It's basically getting shipped out somewhere in a bottle, or it's going into the ground and making corn grow. So I think that we really need to focus on that. And I also would add, and I've said this before, that if we do find a way to discount the clean water project charges, and it has a relationship to how much water actually goes down the drain, then we should do that for residential customers as well. There are some 15,000, if I got that wrong, Scott, you're going to have to correct me, but 15,000 people with irrigation systems?
3,500.
What was the 15,000?
12,000 is the number of backflow prevented devices that we
Okay,
are responsible
yeah, okay.
to DPH.
So that's essentially, you don't have those unless you have an irrigation system, for the most part,
Well, yeah, I mean, there's other reasons why fire protection systems, you might have one property that has 4 devices in it because it's medical or some other rationale of
All right, so
cross-contamination.
we're looking at the ones that actually have irrigation systems, or, like my house, I don't have a fixed irrigation system, but I do like to water my lawn, because I spend a lot of money on making it look nice, and I think a lot of people do. That, you could set a rate that has a maximum amount. So right now, the average amount for a residential customer with a 5/8-inch meter is something like 80 CCFs a year?
It's $410 per year, approximately. That's 100.
That's
assuming
100
CCF, right?
That's 100 CCFs a year, and I thought it was more like 80. Well, let's say it's 100. So that anybody that uses over 100 for a residential customer with, that's using it for irrigation, they shouldn't have to pay more than $410. And think about that. How long are they going to have to pay that $410 a year? How many years are they going to have to pay? That's your share of the clean water project. And, I figured it out. I mean, it's thousands. It's like a second mortgage on your house. You're going to be paying this for a lot of years. By the time we get done with it.
So the thing, and I explained in my email.
You're going to be paying more than $4.
$4.10 today. We still have to spend another $1 billion, and that's why it's very important when I compare ourselves to New Haven, Bridgeport, and Norwich, is that we've already spent $1.7 billion, which is costing our customers $410 a year. We still have to spend another $1 billion. And that's going to raise that rate from $4.10 to upwards of $7.50 approximately. So it's going to double. Even if we get everything we agreed to with DEEP and the integrated plan and get all the grant and loan money that we expect, it's still going to double. And yet Norwich has done nothing. Bridgeport has spent $20 to $35 million, and we've spent $1.7 billion. And yet we're not Very good. And yet, we're not, that's what we're looking for relief. I mean, we're saying, Deep would argue, well, they have consent orders, yes, but you haven't forced them to do anything yet. Yet, we're forcing us to spend another $1 billion when we've already spent $1.7 billion. It's not fair to our customers.
Well, I did this simple math, and just so, I mean, with the 2.6 billion, somewhere in $2.6 billion, the number of residential customers we have that are paying the clean water charge is only 90,000, not 102,000.
Right.
It's only 90,000 people are paying to clean up all of central Connecticut. You will have paid about $17,000 towards that. If it just goes the way that it's going now, you will wind up paying about $17,000 per household for the clean water project alone, nothing else, just the clean water project. And the issue with selling more water is not necessarily trying to make water cheaper. The water would be less expensive if the MDC were what the people that founded it and envisioned it to be, all the communities within a 20-mile radius of the state capital. We don't even have half of those communities as part of the MDC. And the truth is, as long as we have a clean water charge, no one is ever going to join the MDC again. Truthfully, New Britain, Manchester, both of communities, that's another 100,000 people that would be part of the MDC. With just those two communities are well within the 20-mile radius. But we just lost, last year or the year before, Scott, Avon Water Company, the Connecticut Water Company. Avon is it's less than 10 miles. So Avon is well within that, but their water company was sold to Connecticut Water Company, a private water company. And a year before that, Yukon, with the potential for 2 million gallons a day, we could have served Yukon in our franchise area, and Yukon went to Connecticut Water Company, which the state of Connecticut will pay more. That water rate is going to be more than what ours would be to Yukon, and they wouldn't be paying, Yukon wouldn't be paying the clean water charge. So anyway, that's the real issue. We don't have enough people in the MDC to pay for these projects, so.
Okay. Commissioner
I
Patel.
have two questions. Question one, a lot of numbers are being thrown back and forth, including from administration as well as commissioners, that we will break even and a rate will go down to 10 cents. That has to be given in writing, black and white, how, explaining before the public hearing. So public can understand, and we can talk the same statistics, and we can also understand with the same statistics. So we got to share that information ASAP.
Agreed.
The second question is that you sent us the article at EPA, where New York Times article.
Yes.
And towns are fighting going to new EPA, which is now Trump's EPA, which doesn't care for pollution, etc. My question is, us guys, with the cooperation of all member towns and even public plebiscite, we should determine, do you want to go to that route and say, we don't want, please, we are not spending anymore. And if that's what region wants, if everybody wants to deal with that, then a lot of problems will go away. We will have no discussion for another 25 years.
Thank you. We got the questions. I'm sorry. Commissioner Hall?
Sorry, yes, Commissioner Hall.
Thank you. I'd like to request that we consider West Hartford Town Hall for the public hearing. I think there's a lot of people in West Hartford and Bloomfield that would be interested in going. We have West Hartford Community TV right there in the building. It would be a good thing to air. It's also not always convenient for people from West Hartford, Bloomfield to try to get through Hartford at the 5 o'clock time frame. And I would suggest we started off with a little explanation of some of the challenges, because not everybody watches these meetings, and if we could combine that in with the public hearing on what we're trying to accomplish, it might be helpful.
Hartford's more centralized relative to populations from East Hartford and Weathersfield, Rocky Hill.
Could we have more than one?
That's up to the committee.
That's why we picked the training station when we talked, Scott. I mean, the training station is 91 to Bloomfield, 91 right there. Plenty of parking. Rocky Hill right there. The Berlin, Newington comes right up the Berlin Turnpike. West Hartford goes 84 to 91, tremendous parking. I mean, it's an ideal location for
Bus
every
service.
town in the district. East Hartford comes over the bridge, they're there. So I think you have one public hearing, if you have 100 people, that's fine. You have 200 people, that's fine. But I don't think you have to keep this going and going. We've had people coming to meetings for the last month talking on this. We've heard, and then it will come to the board, whether it's for or against.
Takes that decision, right? Okay, the committee, the committee makes that decision. Okay, I'm sorry, let's see, I got Alan, then I'll be back.
Thank you, Mr. Chairman. I want to address something, and I just want to be sure that no offense is taken. It's not intended at all. I very much appreciate when we have members of the public who come in, and especially those who prepare the remarks, which are always very good, very carefully written, and points well made. I received this from Judy Allen, who spoke tonight, before the meeting started, and I read it, and something disturbed me about it, and it was simply this, that I read it again a second time, and then I started paragraph by paragraph, and I inserted the words buy and sell instead of use. We don't think of Niagara as using the water, they buy it. We sell it. It's a perfectly legal and clear, appropriate transaction. So it's not a matter of just letting someone use it or use a little more. We expect to be paid. That's what we do here. That's our business. So I don't really feel badly when we have these discussions about the use of water, the discounted rates possibility, and so forth. And I just want to go back to one meeting ago, and I just wanted to make it clear to the rest of the board that during the, I believe it was a Water Bureau meeting, Commissioner Taylor made a very clear, passionate, and important statement that made it clear that much of the water that we have in our system gets lost in the fact that we have to dump it. We can't sell it. It's gone. We put it into the Farmington River or wherever else it goes. And so I just wanted to make it clear that if anybody did not hear what Commissioner Taylor said, ask him, because he makes it very clear and very simple. And I appreciate that, Commissioner. Thank you.
Commissioner Godot.
Yes, Mr. Jellison's letter to the towns, he talks about the windfall for the $13 million that is owned to us by the deep. If they did pay this amount this year, okay, what would each of the towns get next year with that $270,000 a month? I'd like to know what it would be divvied up to, because Mayor Rell is asking that question, is if they do pay up, what is the ad valorem amount that would go down if the number stayed the same for 2021, okay, and going forward?
So I believe the board has already passed a resolution and it's passed every year, that if we receive any money, whatever that is, if it was mid-year, the money would.
He wants to know the amount.
No, what, I understand.
You want to know,
Windfall.
you want to
What-
know the amount, the net amount that we
It's-
had.
No, like, let's say the decrease going forward, if the $13 million was paid, what would,
It's about $2 million.
It's $2 million a year.
understand that. Divide that by the 8-member towns.
No, you take the
No, it's
percent of
proportional.
the town.
Well, that's what I'm saying,
Yeah.
the percentage of the
2
town.
million, as in budgets, this budget cycle, we had told you that 1% is approximately $500,000. So if you're receiving $2 million in revenue from someone, and it's being applied to ad valorem, then you're talking about approximately 4% reduction year after year.
Yeah, but I guess the question was what the gross amount of money, the $2 million would be predicated on the formula we have and the percentage. We can give you the
Yeah, what's
percentage.
that, what would Weathersfield get, what would Rocky Hill get, what would West Hartford get?
You would get your percentage, so your percentage, West Hartford, I know the number in my head is 23%, so they would get 23% of 2 million. Rocky Hill is, you know, so the percentages are.
We can give you the
Yeah.
printout. We got a printout on it.
Because this chart here, that's
That was,
behind you now.
that was cumulative. You were
That's
asking for it a year to
Year
year.
to year.
Yep.
Commissioner, we'll give you that. We got a printout. We'll just divide it by the.
I know I have it
percent.
someplace in
Yep,
my.
we can give you that.
Yeah.
If you look at, I'm sorry, if you look at the 2-page summary that we've given out to all the towns, and if you don't have it, Nikki can give that to you, in that it also has a chart, and it shows the percentages of ad valorem by town.
By town.
Right,
That's
Nick?
really what it is, the
Yeah,
percentages with the
it's
2
that.
million.
Yep.
That's what we need.
You got it.
We'll give you the printout on it.
Okay. Thank you.
There was, anybody, Commissioner,
Yeah, I was just want to know,
Messina?
maybe it's Mr. Zikes can let me know, but how many employees are eligible for retirement this year? I know over the next 5, we have a substantial. like,
over
25,000.
200. Not this year, but over the next 5.
How many this year?
Bob?
We have the magic number, age and service, so they can go out without.
Bob, could you make that pronouncement for
Did he say 60?
the microphone?
Right now, we have 60 that have magic number. We have approximately 10 to 15 that are already 65 years. That's the normal retirement age. So you're looking at a pretty good number. We're estimating 30 to 35 retirements for this year, 2020. Last year, we had 19. Year before, we had 17. And once we get into 2021, it's the sky's the limit. It's going to be over 150 retirements.
Thank you.
Any further questions? Commissioner Taylor?
Just
Yeah,
clarify, not retirements, potential retirements.
Right.
Because that could be
No one's,
misconstrued by.
we don't have 60
You
commitments.
don't have 60, you don't have 120.
That's the potential pool. Right.
Eligible.
Right.
Commissioner Taylor?
Yeah, I had the unique experience Sunday of getting in a shouting match with one of the constituents in my town, Bloomfield. And it was readily apparent to me that I don't think we have clarified the issues with regard to what we're doing. There is a considerable amount of confusion. I think that the commissioner, a fellow commissioner down here, when he addressed the issue about the Clean Water Project and what it's doing to the water bills, there is considerable confusion out there about water bills and the Clean Water Project. And when you ask people, what are you paying? And have you looked at your bill? They just go blank because you ask someone, how much are you paying for water and what else is on the bill? They give you a blank stare. Then you ask them, and maybe I was sort of baiting the person because I asked them, I was so angry. At that point, I asked them, well, how much do you pay for cable? And the person told me they paid, I think it was $250 a month.
Yeah, 230,
Yeah,
250.
you know, and at that point, I said, well, look at it this way. If we shut off your cable, what happens to you? I mean, you'll probably go stir crazy in your house and with your family. That's one thing. but we shut off your water and your sewer. Just think about that for a minute.
Toilet gets shut up.
You know, people, I think we just got to lay it out better, and I'm not quite sure how we do it. But we've got to do that because, first of all, we're on a course where we may have to go out for more money, or as the commissioner said, we vote not to do it. But I would suggest that you be careful about that because we are under a consent order, and they can always take us back across the street. Am I wrong, counsel?
Absolutely correct.
And if it goes back across the street, then the judge runs it. And that's a different matter altogether.
That was mentioned
Yeah.
in article that many
Okay.
towns in New York
Can we
area-
go through the chair rather than having conversations back and forth?
We got the article here,
Commissioner?
New York Times article, which came in our package. And many cities and towns are going to EPA. All these negotiations, all agreements, they want to dump it. And I know we don't want to go. My point is, public should know if that is the choice we have. We ask public, raise that level, so let them know that, yeah, Weathersfield Cove will have dirty water there for months, or Bloomfield will have this impact. Do you want us to stop all this? And that will raise the issue, and they will know exactly that, yeah, I'm getting benefits from whatever we are doing. Because the people don't see the benefits directly, like watching TV, making phone calls, etc., because water comes in and nobody knows. So at some point in time, we have to raise that issue and have a discussion. Let people know about it.
Most of the benefits of the Clean Water Project are pretty much downstream. It's downstream in the Connecticut River, and it's downstream in the Long Island Sound. So most people really don't see it unless you spend a lot of time either down on the Sound or on the river. But, you know, and as Commissioner Salami has said, basically,
We're getting hungry.
we've got 90,000 people that are responsible for cleaning that up, and that's just not bearable, given the situation that we're faced with. All I'm saying to you basically is I think that we've got to do a better job of laying it out so that people can understand very clearly what it is they're paying for. And one last thing is that, you know, we talk about discounts to people like Niagara or to heavy bottle users or heavy water users. But yet and still, we're dumping pretty close to 35 million gallons a day in the Farmington River that goes out, you know, into the Connecticut River. It doesn't even stay there. So, you know, once again, if we're talking about discounts on water and giving it away, we're giving it away to the fish for nothing. Thank you, Mr. Chairman.
Again, that's one of the issues that we've got to seriously look at is breaking the specific clean water charge out so that people understand what they're paying for, not encapsulated in the water bill. Rich?
May not be a good suggestion, but we could issue two bills.
That's, well, let's have that discussion in committees. We'll be here all night. Any further discussion if, Don?
Thank you, Chairman. Just quickly, the screen that was just up with the ad valorem fees, I would encourage everyone, all the commissioners, if you haven't got it, ask Scott to have it sent to you again. Take your phone, take a picture of that page, and send it to your legislators, not to their government contacts, send it to their personal contact. They're inundated now with the session coming in and new bills. They've got so much to read that they're not going to see a lot.
Commissioner, if I may, it's in the email, and so you have it, and the legislators were copied on it as well.
I know, but they
Yeah.
went to their.
You want to bring it to their attention.
They may or may not see
Sure.
everything.
Yep.
Or want, but they may see it if you send it to their cell phone or their personal email.
Any further questions? If not, the proper motion is in order.
Chairman.
So moved. And accept it.